deal with that first, and then I deal with the motion to terminate probation second. Matter of probation again, please raise your right hand. State you swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Please on your right hand, state your full name for the record.
Nikita Francis for Department of Corrections to Control.
All right, thank you. You may lower your right hand, and counsel for the defendant.
Good morning, Judge. Howard Son on behalf of Field McConnell, who's present by Zoom.
All right, and counsel for the state.
I am Becker on behalf of the state of Florida.
And Mr. McConnell, I need you to raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
All right, thank you. You may lower your right hand, state your full name for the record, and spell your last. Mr. McConnell, state your full name for the record and spell your last.
My full name is Field, F-I-E-L-D, no middle initial, McConnell, M-little-c, capital C-O-N-N-E-L-L.
All right, thank you. And is there anyone else here that's a party or that may wish to speak on this matter, on this McConnell case?
I'm here, Your Honor. Kim Picasio. I'm the victim in this case.
Attorney Picasio, please raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
I thank you. Please lower your right hand, state your full name for the record, spell your last.
Kim Picasio. Picasio spelled P-I-C-A-Z-I-O.
All right, so let's start with the reprimand hearing. Department of Corrections, what say you?
For the most part, this government hearing is regarding a special condition of Mr. McConnell in which he's not to appear on any social media platforms, including things such as YouTube.
It's hard to hear, Judge. I'm sorry. It's hard to hear.
Speak as loud as you can for me. Don't touch it. You gotta let Ms. Frederick do that. But yeah, speak as loud as you. That way, if something breaks, then we can blame her and not you. But go ahead, speak as loud as you can for me.
This reprimand hearing is regarding Mr. Bill McConnell's special condition to not appear on social media or streaming platforms on the internet. It's a special condition that he violated in the past, and he continues to violate. And at this point, the victim and myself for the Department of Corrections are starting to feel that it's a pattern that he's just willingly disregarding.
All right, anything else?
As we're only starting with the reprimand hearing, that's exactly what I have in the report. I'm sure the counsel has reviewed it. I don't know if Mr. Kaiser has reviewed it, but it explains specifically the condition that he agreed or the right he waived, and it has continued to just violate while in situation.
All right, defense counsel.
Judge, I mean, I've discussed this with Ms. Picasio back in July. I've explained to my client what his responsibilities are. I know he has not made any reference to Ms. Picasio in any social media appearances. There was some confusion that the probation officer in Wisconsin mistakenly advised Mr. McConnell that his probation had ended several weeks ago. And I know he went on his social media interview after that, believing that it had expired. But in fact, I've explained to him it has not expired, but that's subject to the second motion I filed to terminate probation. I don't have more information than what's in the reprimand request. I think this does go hand in hand with the motion I filed to terminate probation, of which Ms. Picasio has explained to me on several occasions that she has no objection. Your Honor's just recently become involved in this case, and if you want, I can give you a brief history. This case is going back now almost 3 years, back to November 4th, 2019.
For the reprimand, we just on a reprimand right now.
Okay, I mean, at this point, the court can admonish my client not to continue or make any social media appearances. I know he's abided by the restriction not to mention, refer to Ms. Picasio in any way, and I'm not aware of any allegation that he's done so. I don't know about this part about hiding his face during some interviews or appearances. That again, it's strictly based on what's in the reprimand report, and I have nothing to substantiate that. But I mean, for purpose of this hearing, I'm going to assume he made some statements on social media, which he probably wasn't entitled to do. But again, the biggest concern was when we negotiated this plea, almost over a year ago, was to not have any references to Ms. Picasio, not direct any attention to her. And I know my client is even hesitant to even discuss her name when he and I speak. So he's definitely abided by that condition. If he has appeared on social media or his voice has been on social media, then he does need to be admonished by the court not to continue doing that in the future. And again, I think that's probably the easiest way to resolve the reprimand hearing at this stage.
All right, and State?
Judge, the state agrees with probation and what he had.
All right, and Mr. Picasio, as to the reprimand, do you wish to speak?
Yes, Your Honor. I did call up to the probation officer when these things were going on. And I did explain to probation that I didn't want to, blow things up. This was a relatively minor, if you could call it, violation. And I think the problem was lying in the fact that his Wisconsin probation officer had incorrectly told him that he could appear on the internet without mentioning my name. He got incorrect instructions from his probation officer. I confirmed that with his Wisconsin probation officer, sent him the order of probation again. And then ever since then, I had not seen a violation. So again, I did not want to make a big deal, but I did want to let the court know that I think that he was ill-advised yet again by his probation officer in Wisconsin. So that's my statement on this particular matter.
Right.
I confirm that as well, Judge, that there was incorrect information passed to Mr. McConnell. And since that's been corrected, there's been no subsequent activity.
Go ahead, Department.
If I may clarify,
Yeah.
this TVN predates any appearance or any supposed appearance of whatever they're referring to. Those appearances and the supplement that I received were predate whatever appearance they're referring to. Again, gratefully so, Ms. Picasio does feel that it should not or may not have needed to go any further. Nonetheless, that was not what I was informed of at the time. With that, I did move forward with the reprimand hearing just to remind Mr. McConnell the fact that he did waive his right to appear online. As far as the idea of hiding his face, it's in the fact that he will have things posted, whether it be his account or someone else's account, with his a picture or something else as opposed to a live video of him. If Ms. Picasio feels that she does not feel she's being threatened or intimidated in any way, then the reprimand hearing can be from there. But I think it's trying to ensure that the victim associated case felt heard.
Mr. McConnell, all right. I'm turning to Mr. McConnell. Mr. McConnell, can you hear me?
Yes, Your Honor, I can hear you.
All right, so a court is allowed to early terminate probation. Anybody plan on calling this probation officer that's in what station? Wisconsin? I've heard the testimony, and I've heard the proffer, but I haven't heard from the actual person who's going to prove the truth of the matter asserted. That's the information provided by Ms. McConnell. Anybody seeking to call her at all? Is she here on Zoom or in person?
No, Judge. You can only contact them through the ICOT system.
All right.
The term came about well after the reprimand, so there wasn't enough time to notify them.
All right, Mr. McConnell. Statutory authority to grant a motion for early termination. I'm gonna get to you. I'm still gonna have the motion for early termination, but I'm gonna. This is your reprimand hearing. Authority to grant a motion for early termination supervision is a matter of grace. A matter of grace to the degree that a court's refusal to exercise it isn't even appealable.
What's he saying?
I repeat it, no problem. The statutory authority to grant a motion for early termination of supervision is a matter of grace that is not, it's within the discretion of the court, and the court's refusal to grant it is not even appealable. means after the court consider all the facts and consider the evidence and considers the testimony, if the court feels that you have not performed ideally satisfactory based upon a court order, I've heard from Ms. Ocasio, I've heard from your lawyer. If the court believes that you have not complied with his order satisfactory and that you have not conducted yourself to be an ideal, not okay, not mediocre, not 50-50, court doesn't have to grant it. It's a matter of grace. So with that, this is your reprimand, sir. You ought to comply with any and all court orders, despite what anyone else tells you. I don't care if the Department of Corrections tells you something. I don't care if the lawyers tell you something. I don't care who it is. If you have questions about your terms as to what you, how long you're on it, if you're still on it, first thing you should do is call your lawyer. That's the first thing you should do. And then after that, pull up your disposition, because you should have one. And then that disposition is going to tell you exactly when your probation started, when it's supposed to end, terms and conditions. And then if you still got questions, call your lawyer and ask to maybe have a conversation with your lawyer present with your probation officer, so that whether it's the one in Wisconsin or one in the state of Florida, so that it's clear. Because I got a technical violation notification on this one. I said set for a reprimand hearing. Don't send me any on this particular matter. Don't send me any more technical violations. If he is not in compliance with this probation, submit an affidavit with a warrant for me to review, and I'll make a determination on what I'm going to do from there. All right, this is your reprimand. Now I need a dispo to that effect, please. So you've been reprimanded. Thank you. Now let's turn to your motion for early termination.
Yes, sir.
You're entitled to have one, and I will consider all the facts. All right, defense, what say you?
Judge, the history of the case is somewhat lengthy, and I'll try to make it as brief as I can. Ms. Pacasio is here, so if I misstated, I'm sure she'll correct me. This case goes back almost 3 full years, back to November 4th of 2019, when my client was arrested in Wisconsin. He spent 4.5 months in custody in Wisconsin, waiting extradition to Florida. He came to Florida for his first appearance, February 24th, 2020. He was released on bond less than a month later on house arrest with GPS monitoring at his son's house in Stuart, Florida. He spent 10 months there. Judge Casey then agreed to allow my client to transfer the house arrest with GPS supervision to his home in Wisconsin, where he spent 8 additional months in that situation until the plea was taken in this case on September 13, 2021. So basically you're talking about 22, almost 23 months between incarceration and house arrest before the plea was taken. The plea was to 2 reduced charges of misdemeanors. So we're dealing with 2 misdemeanor counts at this point. He has completed over 1 year of the 2-year probation. It was 12 months consecutive to 12 months probation. There has been some issue, as the court just addressed, regarding Mr. McConnell, appearing on video. I've discussed this motion for termination of probation. I did not file it without speaking to Ms. Pacasio. We've spoken at least 3 times in the past 2 weeks. She fully supports it. She does not object to it. She agrees with me that Mr. McConnell has served a significant sentence for 2 misdemeanor charges. There is still an injunction that was issued by Judge Kaplan in Fort Lauderdale that remains in effect. So even with the probation terminated, Mr. McConnell has certain restrictions regarding his contact with Ms. Pacasio, and he's not had the contact. He's refrained from any contact. Notwithstanding the reprimand, I think based on everything that's transpired in the past almost 3 years, just short of 3 years, this probation should be terminated. Mr. McConnell be allowed to go on with his life. Some other extenuating circumstances. During the pendency of this case, Mr. McConnell's wife was ill and eventually passed away. So he's dealt with some personal tragedy as well as the other issues surrounding this case. So we're asking that the probation be terminated. And again, Ms. Pacasio is here to advise the court as to her position, but she's explained to me that she has no objection as the victim in this case.
All right, before I turn Mr. Ocasio, State and then Department of Corrections. State, what say you?
Good. The state's concern, I understand it was misinformation allegedly from his responsibility. The state's concern is that he knew the conditions of probation and he still violated it. The state's position is that, first of all, that he shouldn't be early term because he has not completed all the conditions of probation. But at the end of the day, if he finds to grant it, the state just wants the judge to keep in mind that we just are trying to prevent this from happening more in the future. That it's the state's position that he's probably going to do this again.
Department?
I'll defer to the court. I will inform you that Mr. McConnell has not had any new arrests. He has paid his full costs. Unfortunately, he has been brought to court twice on two separate occasions regarding the same violation, so that is of concern. But if Ms. Ocasio believes that Mr. McConnell will no longer be of threat to her, then I will defer to
Attorney Ocasio, the victim and Mr. Victim.
Yes, thank you, Your Honor. With regard to this particular probation and the early termination thereof, it should be said that he has avoided any arrests or new charges, although there has been technical violations. And again, we've discussed for the record how that, I have confirmed that was substantially misinformation from his probation officer in Wisconsin. We're looking at a guy who's in his 70s. During this time, it'll be actually 3 years in November that he's been wrapped up with the law. He had no priors prior to this particular case. I think he got swept up with the internet. I think that he lost some of his loved ones during the time that he was incarcerated. He did not get time served, Your Honor. He spent substantial time waiting for extradition in Wisconsin, spent a little time in jail in Florida, but then was on level 1 community control. So that's akin to being in jail. And then thereafter, he pled out to 2 misdemeanors, and we ensured that the sentence there, the probation, ran concurrently. So at this time, I feel that I'm protected by my injunction for protection. I believe, after speaking with his attorney, that it is time to let him go on with his life and to live his life productively as he did before any of this happened. I believe that it would be a hardship if he continued on probation, because I think that he's got family members, et cetera, that he can't, there are onerous conditions, Your Honor, of his probation. It's not just a straight probation. He can't even go on the internet. He can't email friends or family members without putting them on a list. So with that said, Your Honor, since we've been now 3 years with this defendant wrapped up with the system, who had never been arrested before, again, substantially complied. There's been some issues, but nothing that was blatant or led to new charges. And so with that said, Your Honor, I would have absolutely no objection to this man being released from probation, and I could be continued to be protected by my injunction. Thank you, Your Honor.
State, I briefly heard this. Has he had any previous violations or technical violations in the past?
Double check
Hold on 1 second. I'll let you chime in. Well, go ahead, Department. Go ahead.
It was regarding the it was a letter that I had sent to the court. It was read out in open court, and it was treated as a reprimand back in November 2021. So very shortly after he had been placed on, and this one was done more formally in a full technical violation letter.
I got a December 3rd, 2021 reprimand hearing here by Judge Davis.
Yeah.
Other than that, I don't see anything good.
Yes, other than that, there has been no other issues. He was paid for a cause. He has not had any more arrests. I did a records check recently. He hasn't had any more arrests or anything like that. It was specifically this condition that he did not.
And he was placed on, how long was he placed initially? Placed on probation?
September 13th, 2021.
How much time did he serve in custody before being placed on probation?
It wasn't placed on the dispo. His attorney advised 4 months, but that wasn't a condition of probation, so that was never.
It was actually longer, Judge, because it was 4.5 months in Wisconsin. Then when he came to Florida, he spent almost 3.5 weeks in custody before he was released on the bond I just indicated, with the conditions of house arrest, GPS monitoring and supervision in Stewart, Florida, and that was eventually transferred to Wisconsin in the same conditions. So he's either been in custody or on GPS house monitoring and house arrest for close to just a month and a half short of 3 full years, with the probation starting a year ago.
4 and 3, that's 7, maybe 8, 4.5, 3.5. That's about 8 months that I'm hearing that he may have been in custody from the time in the state of Wisconsin and then transferred here.
No, it's less than that. He spent 4.5 months in Wisconsin.
Okay.
He was brought to Florida on February 23rd and released on March 11th. So that's roughly 18 days. So a little over 5 months of actual time in custody between Wisconsin and Fort Lauderdale.
Okay.
Approximately 10 months of house arrest with GPS monitoring in Stewart, Florida, living with his son, and then another 8 months.
What was the order of the 10 months of house arrest? What was that under what? Was that his pretrial release conditions or what?
It was pretrial release, level 1 supervision with electronic monitoring, house arrest, could not leave his residence other than a couple limited exceptions, and that was 10 months with his son in Stewart, Florida.
Okay.
And then that was transferred to Wisconsin, same conditions, same GPS monitoring, January 14th of 2021. So that was another 8 months before the plea was taken. And then since the plea, it's been little over 12 months of probation supervision. So between probation, house arrest, and incarceration, he's been on full supervision for roughly 1 month short of 3 years.
Well, I'm not counting the 10 months on the pretrial release. That's not, I'm not even considering that time period. When is he set the term?
He's set the term September 12th, 2023.
He served a little more than half of the imposed probation.
Consecutive.
So he's just starting the second count.
Counts 1. I got it. Counts 1 and 2 are consecutive and not concurrent.
No, it was consecutive. No, it was 2 12-month probation terms under the misdemeanor charges for a total of 24 months probation, of which he served a little over 12 months.
He has done the 12 months for the first count, and now he's on the second count now.
Right.
I'm reading it differently, Judge. I'm reading it as a 24-month probation, 12 plus 12, of which he served a little over 12 months.
Yeah, I'm breaking it up. Well, yeah, it's 12 on 1, 12 on 2. I mean, your math is exactly the same as mine. Ultimately, the math comes out to be the same, but 12 on 1 and then followed by 12 months for count 2.
No, you're correct. I didn't say concurrent. I did say consecutive in both my motion and here.
Right, I got you.
Judge, but for the prior history, but for the incarceration in Wisconsin, the incarceration in Broward, the house arrest, this might be premature. But I think with everything that's factored in the past 3 years, and we're dealing with 2 misdemeanor charges at this point. We're not dealing with 2 felonies. We're dealing with 2 misdemeanors.
Yeah, but counsel, the question isn't what he was charged with. The question is, has he conducted himself in a manner where this court should exercise authority and grace in letting him off? And I understand what Ms. McConnell was saying, which weighs heavily with this court because she is the listed victim, and I'm taking into consideration of the injunction that's still in place that out of this county. But I also have to take into consideration that he's been before this court now twice.
Well, Judge, just so the court knows, the first time this came up, I think when his probation had just started, probation, I believe Ms. Picasio might have come to the court, and Judge Davis asked, what would you like the court to do? Would you like the court to do anything? And the answer was no. So there was nothing really conducted in court at that point. And just so the court knows, there were several pages of special conditions to his probation. The only one that seems to have been a little issue is this part about appearing on video. The more serious conditions were not to have contact with Ms. Picasio, not to mention her name, things of that nature, which he's fully complied with. So the only issue that he's had has been appearing apparently in several videos where somebody interviewed him. It wasn't him setting up a channel and broadcasting, it was somebody interviewed him. That seems to be the only potential technical violation during the entire time this case has been pending. So I understand the court, we're not saying this, we're entitled as a matter of right, but our position is based on everything that's transpired in almost 3 years, in light of everything considered in this case, with the personal circumstances, with what he's done, what he's not done, which is obviously get into himself any trouble, get rearrested, violate the more serious conditions of his probation. I believe termination of probation is appropriate at this stage.
So because he hasn't substantially violated it, in your opinion, then I should let him off, or he only has had minor infraction?
Not that he only has. It's just the most recent one is a technical for the reprimand, because he was under the impression that he could do this, and he couldn't. But again, it wasn't him setting up a channel, broadcasting and spewing things out to the internet. It was somebody interviewing him that he was told by his officer. And just so the court knows, I did try to reach out to the officer. I've left several phone messages for the officer in Wisconsin, sent him an email, and received absolutely no response. So we did make an effort to try to talk to him, get more information, but he was not responsive.
All right, motion denied. He has not conducted himself as an ideal probationer. I'm not satisfied at this point that the court should exercise its authority and grace. He stay off the internet. He does what he's supposed to do. Then you want to bring it back before this court in the future before it's time for him to term, then I'll consider it. But he's been before this court at least twice for a reprimand hearing. These are when you're placed on probation, the order is an order. That's what it is. It's not an option. You can't parse it and say, well, I'm only gonna, or maybe somebody gave me some bad information. That's why we do court orders, so that it's clear in disposition, or somebody only interviewed me. I didn't actually initiate it. That's not how it works. The standard is clear. You must comply with the court orders. And if you have complied with the court orders and have conducted yourself according in all other respects, special conditions, etc., which is commended that he's done that, then the court can take all that into consideration. But one of the primary reasons why he is on probation are the same, at least with this most recent, is one of the issues concerning contact or indirect contact or third-party contact with the person that he should not be having any type of can't split the thread and the needle and walk the tightrope when you're on probation. You have to conduct yourself up and above par so that there's no issues and no questions as to you doing what you're supposed to do. So on those statements, your request is denied, but the court, as stated earlier, he stays off the internet and continues to do what he's supposed to do. I'm more than happy to entertain any future motions prior to his termination date. Not saying I'll grant it, but you got to conduct yourself accordingly.
Judge, I only one thing, I understand your ruling, but I don't know if you're interpreting what's in that technical violation report to mean Mr. McConnell has had contact with Ms. Picasio, which he has not. There's no allegation that he's reached out to her directly or through anyone else. That's not been alleged, and that's never happened. So if the court is relying on that to deny it, then I have an objection to that. If you're just saying that he needs to spend a little more time on probation to reconsider this, that's another thing. So I don't know if there's a misapprehension or misunderstanding there.
Then next case.
I have a question.
Yes, ma'am.
Okay, the reprimand was on count 1 only, right? And then the motion.
Has he completed count one?
But
So-
the record, it was technical was filed before.
Count one.
All
Correct.
right, that's why I
We're on
wanted to
count
make
two
sure.
now, so.
So count 2 was for the termination and count 1 was
For the reprimand.
Okay.
Yes, ma'am. Thank you for the clarity. All right, everybody. Appreciate it. Next case. Come on up.